Hi, good morning. Thanks for joining the webinar on a critical perspective of third-party funding in ISDS. I'm Brooke Guven from the Columbia Center on Sustainable Investment, and Frank Garcia is also joining us today to present critical perspective of third-party funding. So this webcast is being recorded, and you can also, Frank and I will speak for the first part of this hour, and then we'll open it up for questions at the end. But you'll also be able to ask a question at any point during the webinar, and we can either integrate it into our discussion or we can address it at the end. And you can do that. You should see a question bar on your screen, and you can type your questions that way. So yeah, so with that, I will get started. So today we're going to discuss, I'm having some issues with here we go. So here's the outline of what we're going to talk about today. First, we'll talk about, sort of what third-party funding is, who are funders, how do we evaluate it. We'll present, sort of the case advanced for third-party funding, talk about how it's used in investor-state dispute settlement, talk about potential impacts, and then talk about what is the question on most people's minds: what are potential policy responses? I'll turn it over to Frank to talk about who funders are, and I can also let Frank introduce himself.
Great, thanks, Brooke, and thanks everyone for joining. As Brooke said, I teach law at Boston College Law School, and I've been working with Brooke and the center and a number of students and researchers around the world to try to develop a set of evaluations and policy responses to third-party funding. I don't think I need to explain to this group why this is a significant issue. As you know, the presence of third-party funding in ISDS is growing, although it's hard to get good data, in part because of the secrecy and disclosure issues we're going to be talking about. And there's a tremendous amount of investment capital from the financial community, finance capital, interested in funding disputes of all kinds, and ISDS in particular. For some of the reasons we're going to talk about today, as you know, ISDS is of particular interest to the third-party funding community. And it raises some particular policy concerns that, in our view, are not necessarily the same concerns of third-party funding in commercial arbitration or domestic litigation. So one of the assumptions that we're making as we go through this presentation is that one can make a case for having a unique approach to third-party funding in ISDS. That doesn't necessarily mean the jurisdictions have to also ban TPF in domestic litigation or commercial arbitration. They may want to, they may not, but we believe TPF and ISDS present some unique challenges. So starting with the question of definition, there is, as you know, a sort of strategic element to the very question of defining what third-party funding is. And there is a broad approach and a more targeted approach. And the broad approach, I think the best example is what we find in the ICCA Queen Mary study of third-party funding, which defines third-party funding really broadly to include any party that is offering any funding into a dispute in general or ISDS in particular, whether or not there's a contingent financial recovery, whether or not they're exercising any influence over the way the case is managed. In our view, that's an overly broad definition of third-party funding, because it would bring in funding such as social impact funding when NGOs or Bloomberg or others might be concerned about tobacco litigation, for example. It brings in lawyers on a contingency fee. And in our view, that is not the same as the more targeted, narrow definition of third-party funding that you see on your screens right now. In our view, what defines third-party funding for the purposes of the kinds of regulatory approaches and policy concerns we're talking about has to do with a kind of nexus between the funder offering funding as a means towards a financial return for themselves. As I'll say in a moment, these funders are investment vehicles themselves. So they are getting involved for a financial return. Second, they are exercising some degree of influence over the way the case is managed. And third, they are looking at a role in the case that is unsupervised by the sorts of ethical or legal obligations that attach to parties like attorneys or other financial parties like insurers. So there's a combination of control or influence over the way the case is managed, a speculative financial goal, and an absence of ethical or other kinds of financial regulation on the funder themselves. All right, moving to this question of who they are, this is really important because we want to understand that we're talking here not about traditional productive investment. We're not talking about traditional insurance vehicles that might be available for some of the risks that claimants have. We're talking about investment vehicles themselves. So hedge funds, banks, other financial parties who are organizing capital themselves in order to invest in these disputes for financial return. As you see on the slide, the key is that they have a profit-focused fiduciary obligation to their own shareholders. All right, so how do we, excuse me, I think I jumped ahead. Yeah, okay, so I think we're going back to you now, Brooke, on the question of how we evaluate third-party funding.
Sure, thanks, Frank. So I think that, you know, considering how to evaluate third-party funding, what is its value in any kind of dispute, you know, needs to be a cost-benefit analysis. But what is our ultimate objective, right? The ultimate objective is advancing the object and purpose of investment treaties themselves. So when you look at the object and purpose of investment treaties, I've put just a couple on the screen right now, one older and one more recent. Many, if not most of them, I would say most, if not all, I guess, do refer to some kind of economic development of the home and host state as their object and purpose. So these are instrumentalist agreements. You protect investors with the hope of gaining investment, and you hope to gain investment in order to develop economically. Newer agreements talk about sustainable economic development, and I would say that's because of a broader understanding of how these treaties are impacting, you know, all stakeholders, not just the investor and the host state. So that the sustainability aspect also refers to, you know, the general economic condition of the country and taxpayers and citizens as well. So when you think about what are the costs and benefits of third-party funding, I think it needs to be placed in that context. You know, so third-party funding may benefit certain investors. And is that a good thing or is that a bad thing needs to be evaluated in light of this broader purpose of why we're entering into these treaties in the first place. And once we put it in that context, then it's easier to think about what appropriate policy responses may be in order to ban, regulate, or do whatever you want with third-party funding. But there has to be some anchor of why we want it and what it's used for. So I will let Frank start back with the case for third-party funding.
Thank you, Brooke. So there are two primary rationales that are offered by funders and claimants that use funders in defense of third-party funding. Access to justice and a market efficiency argument. I'm going to address the access to justice argument, and then Brooke will address the market efficiency argument. So what do we mean by access to justice? Well, the term access to justice comes out of a social justice context, context in which access to courts or other dispute settlement fora as a mechanism to address a claim is part of ensuring social justice for a wide range of claimants. It's part of addressing civil rights issues. It's part of addressing patterns of discrimination. So that's the context out of which the term access to justice comes. In this context, the question we have to ask is, what does access to justice mean when it's invoked in ISDS? And here I think it's important to distinguish between access to justice understood as the availability of a remedy for a claimant who seeks to put forward a valid claim versus access to ISDS, for example. They're not necessarily the same thing. Second, we have to look at what is the profile of the investors who are seeking to justify third-party funding on the basis of access to justice. Or what's the profile of the types of clients that third-party funders are looking for in ISDS. We're going to turn to this more throughout the presentation, but essentially we're not really looking at the classic indigent plaintiff or impecunious claimant. We're primarily looking at well-resourced corporations and financial interests that are looking at third-party funding more with respect to case management, balance sheet management, rather than as a means to put forward a claim that they otherwise could not afford to put forward. Now, we do hear a lot of discussion in the investment community, both the claimant community and third-party funding, of so-called impecunious claimants, investors who are not able to afford the cost of ISDS. Insofar as that may be a valid rationale in certain cases, I think going back to my earlier point, there are other ways that potential investors can ensure that they have the resources to bring forward a claim. It need not depend on the availability of third-party funding. So I think we have to take a very hard look at whether there are other mechanisms, such as political risk insurance, such as after the event insurance, or even whether or not the access to national courts themselves ought to be evaluated with respect to whether or not these claimants really are going to suffer an access to justice wrong if they're not able to utilize third-party funding. All right, so Brooke will then discuss the market efficiency arguments.
Sure. So the other justification often advanced in favor of third-party funding is this idea of creating market efficiencies or leveling the playing field. And I would say that this argument is advanced more broadly. So when third-party funding is used in domestic courts or in commercial arbitration or in other contexts, this is really the argument that's relied on frequently. So I would say there's two aspects to this. The market efficiency comes from the idea that funders create a market for legal risk where there was not one before. So that is to say that companies who don't want to bear this legal risk are able to offload it to a party who actually wants to and seeks to bear this legal risk, and indeed has a profit, has a business model based on, taking that risk for profit. So this is a market, that insurance fills the same kind of need. It's offloading risk to a party who wants to bear it. And then there's another aspect to this. And so I would say that funders, the other part of this is that this leveling the playing field kind of idea. So the idea is that funders are repeat players in this system. They have insider information, they have access to sophisticated counsel, they can evaluate claims, they can really understand the nitty-gritty of how a claim is going to advance, how a tribunal will apply the law to those facts, and what the anticipated award is going to be. So they're viewed as sophisticated players, and indeed they do have a lot of expertise. So the idea is that if you take one of these sophisticated players and pair them with sort of a one-time claimant, that they can level playing fields, that they can align this risk-averse one-time claimant with this repeat player, and then they can sort of elevate the parties so that they have equal bargaining power in a settlement discussion. And the idea is that this can increase the probability that a settlement will be based on the merits of the claim, as opposed to just the party's risk tolerance. So if you have one party with strong bargaining power, the settlement may reflect the bargaining power and not the actual merits of the claim. But I think we really need to ask whether this is the case in investor-state dispute settlement. So, so in investor-state dispute settlement, and I'm sure many of you on this webinar are also questioning this right now, obviously this varies by respondent government, but many respondents in ISDS, just because of the asymmetry of the system, are not in positions of bargaining power. So they're, the bargaining power and the risk tolerance of states is extremely skewed versus claimants. So, there's a study saying that even one case against a respondent state decreases its attractiveness as a site for FDI. When you start to look at how respondent states, and I'm talking to, respondent states, but, this is a risk tolerance position that's already skewed heavily in favor of claimants in many cases. And then when you look at the availability of respondent funding, which we're going to talk about in just a little bit, in ISDS, you really only have claimant funding that's available. So you have a claimant who's paired with a funder, a very strong, well-resourced funder. And on the other side, you have a respondent state where there is no funding available. So these sides, it's just exacerbating this power asymmetry that's already present just based on, the structural aspects of ISDS itself. So, and then when you look at the statistics of who are respondents and who are claimants, most respondents are low or middle income countries. Most claimants are large and well-resourced enterprises. So, this addition of third-party funding on the side of these large, well-resourced enterprises against low and middle income countries is just skewing this, everything that's already problematic about investor-state dispute settlement even further. So let's talk about how third-party funding is used in ISDS. So, and I think I was going to cover this, Frank. Yeah. So first, just the logistics around or sort of when does funding occur and how is it used. So some funders fund only a portion of costs and some fund all costs. And then funding can either come in at the beginning of the process or later on. So every funding arrangement is different. These are really business, contracts for financing, and funders refer to these claims as investments. So they're going to invest in this asset at any point really that they see a viable investment. And the permutations around how that can work vary by every claim. Some funders will require a lot of influence and decision-making over how the claim is managed. And some take a very hands-off approach. Some of the decision on the funder can be a result of the seat of, the arbitration and the rules that apply in that seat, and some may just be a decision on the part of the funder. But all of that is going to be contract-based rights. So those rights of the funder will be based in the funding agreement itself as to what aspects of the claim they can control, how much information they get, when they're updated by the claimant as to the status, what their participation rights are vis-a-vis the claimant and the claimant's lawyer. So all of these things will be controlled by the funding agreement itself. So when we talk about claimant funding is really, what we think of when we think of funding. Money is put into a special purpose vehicle. Often, these are in low tax jurisdictions, offshore. There's a funding agreement that outlines all the rights and obligations between the funder and the claimant. So this includes things like taking a security interest in the outcome of the claim. It includes when and under what circumstances the parties can terminate the funding agreement. It refers to how much information and to what extent the funder is able to manage the claim. So that agreement controls really most things. So funders consider a lot of different factors when they decide to invest in a claim. I've put a long list here, and I can share these slides afterward. But really, each of these aspects is going to shift depending on who the respondent is, who the claimant is. It's a big picture assessment. And basically, every say you have, anecdotally, for example, I've heard a funder say, we would never fund a claim against the United States because they're very unlikely to lose. And I've heard another funder say, we would never fund a claim against, a completely impoverished government because we wouldn't be able to collect on that claim. So depending on all of the circumstances of a claim, each of these factors is going to take on different kind of importance. So respondent funding, I'd be curious to know structures that any government has actually succeeded in using and what the circumstances for that were, because I do know it has worked in at least one claim, anecdotally I've heard. But this varies significantly from claimant funding because of the asymmetry of investor-state dispute settlement. So, and by that asymmetry, that also means that counterclaims are not available. So or for the most part, not available. So there's really no financial upside for a respondent. And so therefore, there's no financial upside for the third-party funder. So the economics of this are completely different than what is used for a claimant. So in most cases, the way that this would ideally be structured would be something more akin to after the event insurance. So after a claim is brought, a funder and a state could sit down and decide, what is the foreseeable liability of this claim? What do we think the tribunal is going to award? Is this a $15 million claim? Is this a $50 million claim? How is the tribunal going to apply the law to the facts here, and what is the outcome going to be? Then the funder and the state could agree that any award sort of over that amount, you can hedge your risk. So the state can pay the funder pretty much to offload some of that risk. So anything over that amount, the funder will bear that risk. And anything under that amount, the funder may, will basically get an insurance payment for taking. So it's really, the state is always going to be paying for defense, and states can limit risk but not eliminate risk in these cases. And I'll go into this in just a minute, but funders can also cross-collateralize claims. So say a government has domestic law claims against this particular claimant. They may be cross-collateralized so that the funder could take an interest, a security interest, in some of those domestic legal claims where there might be a financial upside in exchange for paying for the defense of the ISDS claim, or in exchange for being on the hook a bit for an ISDS claim. I think one policy question is, under what circumstances can and will governments enter into arrangements where they may have to grant control or access to information to a funder over these claims? But that's a different question. So portfolio funding is something that funders use to limit their own risk. This is where funders create a basket of claims, usually centered around one claimant or one law firm, and it permits risk diversification. In theory, it can lower the cost of funding for claimants. One thing it does do is it also it allows high risk claims and low risk claims to be placed into a same basket. So for example, a claim that's going to go all the way through to an award and no one really knows how it's going to come out, versus a claim that's already in settlement discussions. So, you can diversify your risk that way, and the shareholders still can come out ahead on these baskets of portfolios. So one interesting thing about this, though, is that the creation of portfolios really allows securitization and a secondary market for institutional investors who, sort of insurance funds or other kind of funds who aren't the third-party funder themselves, but are institutional investors who may want to diversify their own investment portfolio away from stock markets or other kinds of things. So these are really becoming financial assets, and these claims are bundled, securitized, and sold onto a secondary market. This is good for funders because then they can free up more financing for more claims. But it really raises serious policy questions about, what should the role of the funder be in these claims when we're talking about, the impacts that they have on many, many people. So let's get into some of those impacts. And as Frank mentioned at the beginning, I'm not going to be covering here a lot of the sort of issues that are being discussed in UNCITRAL and other, and ICSID about conflicts of interest between third-party funders and arbitrators, because I think that that's fairly clear, and then also situations about security for costs. But if there are questions about those, please do ask them and we can address them at the end. So I'm going to talk about some other kinds of impacts that aren't being discussed, but I think should be discussed based on the unique context of ISDS and how third-party funding is working in that context. And I would have to say that empirical evidence is quite low because of the lack of transparency about third-party funding in ISDS. But based on other evidence and what we do know about how it's being used, there are serious concerns around these issues. So I'll talk about each of these in turn. So I'll go through impacts on the number and kind of ISDS cases, impacts on select criteria or qualities of respondent states, impacts on the quality of cases, so looking at marginal and frivolous claims, impacts on the actual substantive development of investment law, impacts on the outcomes of disputes and decisions to settle claims, impacts on retention of FDI, and then impacts on regulatory chill and state conduct. And it seems long, but we'll try to go quick. So So I want to start off by just saying that a lot of these impacts come not only from the asymmetry, but because ISDS is a system of standards and not rules. So when you have a system of standards, so a rule would be, you can't drive faster than 65 miles an hour. And it's very clear when someone has broken that rule. 66, you have broken it, 64, you have not. Standards are vague. What is fair and equitable treatment? This is a standard that's hard to understand ex ante what that means and to conform behavior to that expectation. So ISDS is a system of standards, and in standards-based legal systems, the party who has to conform their behavior is generally the party who bears the cost of the looseness of those standards. So standards-based legal systems can work to the extent you have sort of precedent or appellate mechanisms that help to shape and inform what the law means. But ISDS, as we all know, does not have those features. And moreover, ISDS awards are rarely set aside and are not subject to appeal. So the standards-based system in ISDS really exacerbates that asymmetry that is already present. And then when you add TPF on top of that, it really makes it go even further. So I just wanted to have that background as we go through these. So how can third-party funding impact the number and kind of ISDS cases? So funders claim that they only invest in 10% of claims that are presented to them. Anecdotal evidence suggests that might be higher, but it's really hard to know because there is no evidence of the extent of the claims that are invested in. But I think the bigger concern here is whether some sectors or some kinds of claims are being, funded more than others. So for example, when you look at investments in infrastructure and extractives claims, those are about 60% of all claims. These claims are particularly attractive to funding because of the high damages awards and the expectation damages that are possible in these kinds of claims. But as everyone knows, these claims also have extensive social and environmental complications that often go hand in hand with and sort of underlie the factual circumstances that led to the claim in the first place. And they are often very controversial because the claim itself frequently stems from governments, balancing the rights and interests of many, many different parties. So when you take an already complicated context in which claims are being brought and you add third-party funding, if third-party funding is indeed exacerbating the number of these kinds of claims, that would be a policy concern that should be considered when we think about regulating or looking at the impacts of third-party funding. So the second is, how might third-party funding impact certain kinds of respondent states? So the question is, are certain countries or certain country profiles bearing an outsized burden of these kind of claims? And as you recall, I had placed that list, at the beginning of what funders consider when they decide to invest in a claim. And without knowing what claims are being invested in, it's hard to know. But the question is whether developing and middle income countries that already bear an outsized burden of the ISDS claims overall are bearing an outsized burden of third-party funded claims as well. Or, for example, whether countries that have extensive resource extraction projects going on are bearing an outsized burden of third-party funded claims. So these are already targets of most ISDS claims. So, whether or not third-party funding is impacting this is a serious concern when you're looking at the ability of governments to regulate in the public interest and for intra and international inequality concerns. Then there's the potential impact of third-party funding on the quality of cases. So we often hear, opponents of third-party funding say it's going to increase frivolous claims, and third-party funders say, why would we invest in a frivolous claim that we know is not going to succeed? But I think that's not the right question to ask in this context, because as we already discussed, ISDS is a standards-based legal system, and tribunals are highly, highly unlikely to declare any claim frivolous. You can have the state parties to a treaty all say that a claim is without legal merit, and tribunals still say that the claim, is not frivolous and that it deserves to, jurisdiction should be accepted and the claim should go forward. So tribunals are highly unlikely to declare claims frivolous. So I think the real question is on marginal claims, and these are the claims that are outside of the intent of state parties when they entered into the treaty and granted treaty-based rights to investors, but that are sort of pushing the boundaries of that law. And to the extent that only investors can bring claims, this means that the law is only going to be pushed in an investor-friendly direction, which really sort of brings me to my next impact, which is impact on the substantive development of investment law. So, you know, a lot of times when we talk about ISDS and its overall value, it's, you know, sort of this idea that it upholds the rule of law. But many cases are, of course, much less clear. And what does the rule of law actually mean? So, you know, good faith bans on extractive projects. These kind of bans can frequently be challenged, and it's not necessarily a rule of law question. It's often a fair and equitable treatment question, right? So, so when we think about, you know, the highly complex legal and factual situations that lead to investor-state claims, and that only investors can initiate claims, the question is whether or not investors may be able to push the boundaries of the law in a way that's more favorable to them. So, and then I guess the question is whether third-party funding exacerbates that. So just this week, there was an article on IA Reporter about how a funded claim is now challenging a denial of jurisdiction based on an implicit legality requirement. And it came out that this implicit legality requirement was also applied to a claim less than a month before that. You know, so while that may be something that is occurring in the context of that claim alone, challenging denial of jurisdiction based on implicit legality requirements is clearly in the long-term interest of a funder. A funder can have more claims to the extent that that requirement is read out of treaties. So, you know, the fact that funders may, you know, I think it's a question of who is driving those kind of claims and whether the claims themselves are pushing the boundaries of the law or may even be intended to push the boundary of the law. So we don't know that much about whether and to what extent this is happening in investor-state dispute settlement, simply because we don't have empirical information about what claims are being funded. But if you look at research that was done in Australia, Daniel Chen found that third-party funding not only leads to more claims, it also leads to more claims that push the boundaries of the law and that are cited more and thus have an impact on the long-term development of how the law is actually developing. So to the extent that's happening in investor-state dispute settlement, or to the extent that, you know, funders are intentionally even doing this and we have no idea, that's a serious cause for concern. But pushing the boundaries of the law is clearly in the financial interest of a funder. So I think it's something that should be questioned. And then whether or not funders have impacts on the outcome of disputes or decisions to settle claims. So funders' interests does not always align with claimant interests, which, you know, to the extent the claimant is interested in settling the claim, it may align in certain cases and it may not. But funders have no fiduciary obligations to claimants, only to shareholders. So settlement of a claim and who is driving the settlement and why could be something, you know, like the funder wants to settle within a certain fiscal year, or the funder has a portfolio of claims and, you know, may be interested in pushing one claim that has an interesting and novel legal issue through to an award to see what that award will say, and then will decide to settle others in order to balance the risk of that claim. So, you know, who has control over decisions to settle is actually a massive public policy question that we should really understand more about who is driving settlement discussions and decision making within the context of individual claims. And, you know, settlement in ISDS has a lot of other public policy issues that Lisa Johnson and I have written about. So in domestic legal systems, government settlement of claims is often regulated for issues of transparency and accountability and participation, you know, impleader and interpleader of necessary parties. None of that exists in investor-state dispute settlement. So, so settlement issues are complex and should be addressed here. Whether or not third-party funding has an impact on the retention of foreign direct investment. So FDI can help long-term development, things like tech transfer, the ability of governments to develop. And in theory, if investment treaties are achieving their objective, they help both attract and retain FDI. We all know the evidence on whether they attract FDI is debated, but there are concerns that they may not help retain FDI. So to the extent an investor can get expectation damages, it may make more economic sense for the investor to sue and settle a claim and leave than to work out these long-term complex relationships, based on contracts with incomplete terms, et cetera, that are required for a long-term, particularly infrastructure or extractive investment, for example. And then there are questions of whether there are impacts on regulatory chill or over-deterrence. So the question is not whether government action should be constrained, because government action is constrained in many circumstances by domestic law, by other international legal arrangements, human rights, trade. The problem and the concern that I have with ISDS is that it goes beyond these other kinds of legal frameworks in constraining government powers to the extent that it can unduly discourage good faith actions, and the standards that are in investment law are really the root of this. These vague standards make it difficult for states to understand when and to what extent they can take actions and at what point they're going to violate a treaty. So to the extent third-party funding is exacerbating these situations that already exist of regulatory chill and over-deterrence, this is a serious concern. So after I've laid those out, Frank and I would now like to discuss some potential policy responses that could be taken to address these kinds of concerns in third-party funding. So I'll turn it back over to you, Frank.
Well, thank you, Brooke. So just to summarize what Brooke has laid out so carefully, we have at least three different kinds of concerns going into the question of regulatory and policy responses. There are concerns around the structural integrity of ISDS and investment law itself. There are policy concerns about the way that some of the structural issues in ISDS and BITs are being taken advantage of with respect to a particular class of investors, third-party funders, and the kinds of effects that's creating on states. And finally, some basic fairness questions. Looking at the nature of the system, the nature of the funding, is it fair to increase the amount of resources available to certain categories of claimants while not increasing resources to states which find themselves increasingly burdened by these kinds of cases? So what can we do about this? Well, I think the place to begin is to ask a series of questions about how we should even approach the question of whether or not we should ban or regulate third-party funding. As I said at the beginning, one initial assumption that we're making is one needs to distinguish between third-party funding in other settings and third-party funding in ISDS. For the reasons I mentioned, a state interested in banning third-party funding in ISDS should not feel that it's also constraining itself to ban third-party funding in all cases of its own domestic litigation or even commercial arbitration. They present different issues. So one, it is capable to identify a strategy that only focuses on banning or regulating third-party funding in ISDS. Second, ideally speaking, we would like to make policy decisions based on the richest possible empirical record. However, in this case, the empirical record is not fully developed. Why? Well, it's the nature of ISDS and the nature of secrecy that funders themselves and the investors that rely on them have very assiduously guarded. So the fact that we have a relatively underdeveloped empirical record is a problem for regulation, but we should be clear that the problem comes from the secrecy of the practice itself. So we have to be able to try to make the best possible decisions in the absence of complete empirical record. I think in that context, it's very important, as Brooke mentioned earlier, to approach the question from the point of view of the object and purpose of investment law itself. And we should be fundamentally concerned about whether the presence of third-party funding or the role of third-party funding as currently designed is or is not fulfilling the object and purpose of investment treaties. And this goes back to the fundamental rationale for having banned third-party funding across common law jurisdictions for centuries. which comes under the terms of maintenance and champerty. Some of you may be familiar with those terms out of common law. The basic concern there was that systems to resolve disputes or provide justice should not be turned into opportunities for third parties to make pecuniary gain unrelated to the case itself. So really, in undoing the prohibitions against maintenance and champerty, the jurisdictions that have done so have presented us with a challenging set of questions. What are the effects of that relaxation of the rules in ISDS? I think we have to look at this from a multiple set of strategies. If we're going to consider banning third-party funding, then we have to look at it from a wide-ranging sites in which third-party funding can be effectively banned. No one strategy is going to, by itself, take care of the risks that third-party funding pose. So focusing for a moment on the question of banning, I think the strongest possible argument that one can make with respect to banning third-party funding is that given the nature of the asymmetry of the ISDS BIT system, and given the nature of the pecuniary interests, the speculative financial interests of third-party funders, the BIT ISDS system is fundamentally a flawed mechanism for allowing third-party funding into any dispute, because it has the risk of tremendously magnifying the pressure on states that comes not from the development goals of traditional investment, but from the speculative financial goals of third-party funders. If you allow them to have a role in ISDS, what you are allowing is one set of actors with speculative financial goals to influence selection of arbitrators, case management, which cases are brought, all of the impacts and effects that Brooke was cataloging, in a manner that doesn't ultimately yield any development benefits for the states involved. So I think fundamentally we have to look at that as a powerful reason why, even in the absence of a full empirical record, we have to consider banning third-party funding based on what we know of the structure of the BIT ISDS system, what we know of the incentives of third-party fundings, and what we can conclude would be the effects of allowing third-party funding unregulated in the ISDS context. I think it's worth pointing out, as we have in the bottom of the slide, that one of the fundamental reasons why ISDS is different is in a case of commercial arbitration, for example. You have a business on the one side of the arbitration, a business on the other side of the arbitration, and let's say they're both corporations. Both sides are going to ultimately bear, the shareholders of both sides are ultimately going to bear any residual cost of awards. Here, the residual risk bearers of ISDS are the shareholders of the respondent state and the public budget and the public goals of the entire community, taxpayers of the respondent state, not the shareholders, excuse me. All right, so how do we go about regulating it? So let me hit a few points, and then this may be a place where we have questions or discussion that follows. If we're going to ban it, you need first of all to consider, can it be banned in investment treaties? Now, investment treaties are notoriously different to amend, but we are operating in a time in which a lot of new investment treaties are being negotiated. So one opportunity would be to ban third-party funding in an investment treaty. And that would effectively take third-party funding out of the context of disputes between the parties to that investment treaty. Another approach would be to ban third-party funding in arbitration rules themselves. This is what you're going to be looking at in the UNCITRAL meetings this week, of course. ICSID has been considering the question of third-party funding, although it doesn't look like they're going to propose or even consider banning it. So you're going to need to distinguish between the approaches that are available in UNCITRAL and the approaches that might be available in ICSID. UNCITRAL and ICSID present different enforcement problems. As you know, UNCITRAL awards have to be enforced through the New York Convention system, whereas ICSID awards are automatically enforced. So if you allow third-party funding in ICSID, but you don't want, as a respondent state, to be paying third-party funding, third-party funded awards, you're going to face an enforcement issue. I'm going to turn back to that in a second. If you're in UNCITRAL and a third-party funded award comes through the system, you do have the option at the enforcement stage under the New York Convention to object to the enforcement of that award on public policy grounds. This means it's important to also consider, as a jurisdiction, banning third-party funding in your domestic law, because then you can object to the funding, object to the enforcement of a third-party funded awarded claim at the enforcement stage under the New York Convention on the grounds that it violates your public policy. Turning back to the ICSID question for just a moment, I think states that are interested in banning third-party from ICSID arbitration are faced with a difficult choice. Unless ICSID bans third-party funding in its rules reform, which looks unlikely, then a state is either going to have to pay those awards in ICSID, or it's going to have to try to take a stand at the level of enforcement, which means deciding either on fundamental change of circumstances, grounds, or others, that it's not going to enforce an ICSID award that is third-party funded. And then it will face a dispute with other states in ICSID, possibly an ICJ action. It's a complicated scenario. Or down the road, states might want to consider in their investment treaties agreeing only to UNCITRAL arbitration or ad hoc arbitration and not to ICSID arbitration, perhaps for third-party funding reasons or other. All right, turning to the option of regulating. There are a wide range of issues in regulation, and as Brooke mentioned, we're not going to cover all the regulatory issues. Some of them are already well studied and well developed. If you're concerned about the systemic and policy effects of third-party funding, and yet you believe it ought to be allowed either for access to justice reasons or simply to gain the empirical data that you might want to regulate down the road, then first of all, it's important to ensure that there's mandatory disclosure of the presence of third-party funding in the case and the identity of the funder. Now, this has been pursued, for example, in the Canada-EU investment chapter of the Canada-EU trade agreement, where there is an obligation that the presence and identity of third-party funding be disclosed. We consider it advisable to go further than that, to disclose not just the identity and presence of third-party funding, but also to disclose the terms of the third-party funding agreement itself. This can be material for many considerations, such as which party is going to bear the costs of a security for costs award. Is it going to be the third-party funder, or is it going to be the original investor? Questions about settlement. Going back to the fundamental point Brooke made earlier, who is driving this case? The terms of the funding agreement will shed important light on that the tribunal and the parties need to understand. So we would recommend mandatory disclosure and mandatory full disclosure. There are other issues that come up on a range of the other risks that are brought up, whether or not there ought to be ethical norms or other kinds of either ethical or legal supervision of funders, whether the tribunal ought to be given some sort of jurisdiction or supervisory role over the funder and their involvement in the case, whether in fact you might need to create a sort of means test where an investor ought to demonstrate that they have a financial burden that requires third-party funding in order for them to pursue the case. Now here it's very important to make sure that whatever financial test is developed, that it take into account the ability of multinational corporations to shift assets out of the investment vehicle and therefore demonstrate a kind of impunity that's really an artifact of corporate finance and corporate strategy, and not the same as the sort of disadvantaged plaintiff that you might see in access to justice situation. All right, I realize that I already jumped ahead in terms of looking at the multi-pronged approach. It is challenging, but we think it's an important case to consider. We think it's a winnable case to make, and we think the stakes are certainly high enough for all of the states that you're working with and representing. Brooke, did you want to add anything to the practical or policy side of it before we take any questions?
No, well, just one thing, but if anyone does have questions, please feel free to type some. I just wanted to add one thing. We had a question in the registration form about, how a funder could be brought under the jurisdiction of the tribunal. So I think that when we're thinking about regulating third-party funding, There are a lot of options. And, this would, like Frank said, have to be looked at through the lens of arbitration rules and treaties primarily. But you could do things that place, as Frank already mentioned, place the burden to demonstrate a need for funding, and and that would then require disclosure of why that need is there on the claimant, instead of just assuming that third-party funding is allowed and trying to regulate its impacts. And the one thing that you could do is, for example, in order to have the funder under the jurisdiction of the tribunal for issues like adverse cost awards or other kinds of enforcement or ethical obligations or anything, is just require the consent of the funder in order to provide funding. If the funder is going to be providing funding in a specific claim, they have to consent to certain things and certain oversight by the tribunal. And this could be accomplished through the arbitration rules or through treaties. So I think there's a lot of different ways we can start to think about how to bring funders into this context that that could help to sort of be more nuanced in regulation than just saying identity of the funder and funding has to be disclosed, because that really doesn't get at all of these policy issues that arise from simply the existence of funding in these cases in the first place. So yeah, with that, I think I'm done, but we'd be happy to take any other questions. So I don't see any coming in right now. So we may just, here, let me actually put up, here's Frank and my email. So if anyone does have questions that arise at any point, please feel free to email us. And we can circulate these slides around to everyone who's been participating. So with that, I'll sign off. Thank you very much.
Thank you.